legal precedent set in the case of Mahmoud versus Taylor, the Supreme Court held that a Maryland school district's policy of not permitting parents to opt out of instruction involving LGBTQ storybooks violated the parents' right to free exercise of religion under the First Amendment.
The core responsibility for the education and also the values being instituted into your children. Is it the parents? Is it the state?
Now I don't know what my child is being taught. I don't know what my child is being fed mentally and spiritually, and that's dangerous.
We were made to feel like we were somehow pariahs for saying, wait a minute, Montgomery County, let's bump the brakes.
For a child of 5, 6, 7 years old, introducing any type of material that has to do with sexuality, I would be absolutely against that.
In 2022, a school district in Maryland made a decision. They didn't announce it. They didn't vote on it. They just did it and counted on you not noticing. They told you this was a story about culture war, about conservative parents trying to ban books from public schools. That framing was designed to make you feel like your concern was unreasonable. It wasn't. Here is what they left out. The parents in this case did not ask the school to remove a single book. They did not ask the school to stop reading these books to other children. They asked for a phone call, advance notice before the lesson, so they could take their child to the library for 30 minutes. That's it. That's the entire case. And Montgomery County Public Schools, MCPS, spent $6 million of public money fighting it. A phone call before the lesson, a trip to the library, 30 minutes. MCPS said no. Then they fought that no all the way to the Supreme Court of the United States. And they lost, 6-3. And when the bill came due, $6.1 million of public money, that number was buried so thoroughly that most national outlets never reported it. You already knew something was wrong here. Here's what it actually is. If this had been allowed to stand, and 2 federal courts had already said it could stand, then any school district in America could adopt this model. Introduce curriculum designed to reshape how your young children think about gender and faith. Grant opt-outs briefly to manage political pressure. Wait for the opt-out volume to become administratively inconvenient. Then revoke it by internal memo. No vote, no hearing, no process. Your child's religious formation would then be subject entirely to the government's judgment about which values are inclusive and which are not. That is not religious freedom. That is religious permission, granted and revoked at institutional convenience. I am John Gray. Let us follow the logic. Here is the sequence. Follow it carefully because every step matters. November 2022, Montgomery County Public Schools introduces 5 new LGBTQ-inclusive storybooks into classrooms from pre-kindergarten through 5th grade. Children as young as 3 and 4 years old. Late 2022 into early 2023, parents object. Muslim families, Catholic families, Ukrainian Orthodox families, Jewish families, a coalition that does not fit the mainstream framing of who these parents are. MCPS agrees to honor opt-out requests. This is consistent with MCPS's own written guidelines for respecting religious diversity. The system works. March 2023, the opt-out requests become frequent. Internally, MCPS concludes the volume is, and I am quoting directly from the record, too disruptive. No vote, no public hearing, no legal process. The board issues a statement, quote, "Students and families may not choose to opt out of engaging with the storybooks, and teachers will not send home letters to inform families when inclusive books are read in the future." End quote. They revoked a right they had already extended, without a vote, without notice, without a legal basis to do so. That is the action. That is what this case is about. May 2023, families sue, represented by the Beckett Fund for Religious Liberty. The Federal District Court rules for MCPS. The Fourth Circuit Court of Appeals rules for MCPS. 2 courts say parents have no right here. June 27, 2025. The Supreme Court of the United States reverses. 6-3. Strict scrutiny applied. MCPS failed it on every ground. Justice Alito writes for the majority. The right of parents to direct the religious upbringing of their children would be an empty promise if it did not follow those children into the public school classroom. I want to make sure you heard that clearly. The school district's argument, the argument that 2 federal courts accepted, was not that these opt-outs were illegal. It was not that they were harmful to other students. It was that too many parents were requesting them. It was administratively inconvenient. This is what it looks like when an institution stops pretending to respect you.
Walked on, and that we can use our common sense and know that the laws of our land do protect us.
Now let me tell you who bore the cost of that decision. There was a Catholic mother in this case, a plaintiff named Grace Morrison. Her daughter has Down syndrome. Here is what she said. The school board took away my family's ability to raise her according to our faith. Given her learning challenges, she struggles to grasp why her parents and teachers might disagree. And here is the number that broke 9 days ago and that most national outlets still have not reported. $6.1 million. $1.5 million in the settlement itself. $3.6 million in court-ordered attorney fees. That means MCPS was ordered by the court to pay the family's legal bills because the position was that wrong. And $1.3 million in MCPS's own legal costs. Total, $6.1 million of public money to fight a mother's right to get a phone call before the lesson. They're counting on you not paying attention to that number. Here is how the mainstream press covered this story. Culture war clash. Conservative parents versus LGBTQ inclusion. School book ban fight reaches Supreme Court. The frame is always the same. Parents trying to erase something. Parents as the aggressors in an inclusion fight. If this had happened to liberal parents, if a school district in a conservative state had stripped progressive families of the right to be notified before a lesson contradicting their values, it would have been the lead story on every network, every night, until the superintendent resigned. You know that is true. Now, Justice Sotomayor, dissented. 38 pages. She warned the ruling would create, quote, chaos for this nation's public schools. Her logic. If religious parents can opt out of this, they could demand opt-outs from evolution, from history lessons mentioning gay historical figures, from anything that touches their beliefs. A door that cannot be closed. Run the logic bridge test. Here is what the record shows. After the ruling, MCPS created what they call the refrigerator curriculum opt-out system. The district has 156,000 students. In the first 4 months after the ruling, the number of families who used the opt-out was 56. Not 5,000, not 500, 56 families. Sotomayor predicted chaos. The actual number is 56 families. Part 3. The call to principle. Let me bring this home. The First Amendment's free exercise clause does not say the government cannot prohibit your religion unless it is administratively inconvenient. It does not say, unless the institution disagrees with the religion. It says the government cannot prohibit the free exercise of religion. Full stop. Justice Alito found something important in the teacher guidance documents that most news coverage did not discuss. Those documents did not just introduce books. They directed teachers to challenge students who expressed religious views about marriage or gender. If a child said 2 men cannot marry, a statement of their family's faith, the teacher guidance instructed, respond by asserting that when adults grow up, they can marry whom they choose. The Supreme Court majority reviewed those documents, and they found that this was not passive exposure to a viewpoint. This was an active, teacher-directed effort to, and this is Justice Alito's word, disrupt children's religious understanding of the world. In a compulsory education system, where parents face fine or imprisonment for keeping their children home, that is not a curriculum. That is a mechanism. If the Fourth Circuit's ruling had been permitted to stand, any school district in America could have adopted this template, introduce ideologically targeted curriculum, grant opt-outs briefly, wait for the volume to become disruptive, revoke access by memo. Compulsory attendance laws would ensure parents had no practical exit. The only protection for your right to pass religious values to your children would be the government's discretion about which values merit protection. That is not religious freedom. That is religious permission, revoked at institutional convenience. 4 days ago, on March 3, 2026, the Supreme Court issued an emergency order in a California case. Parents there had been fighting a policy that allowed schools to socially transition their children, change their names, their pronouns, how they were addressed at school, without telling the parents. The Supreme Court ordered California to allow parental notification. And in its order, the court cited Mahmoud v. Taylor directly. It called Mahmoud controlling precedent. It said California's policy would likely not survive, and I am quoting, the strict scrutiny that Mahmoud demands. Mahmoud is not history. It is live law. Right now, today. This is your government. This is your child. This is your call. Before I close, I want to give you something, because I know you are going to have this conversation. Someone is going to tell you that the parents in this case were trying to ban books, that this was a conservative attack on LGBTQ children, that the Supreme Court handed the religious right a weapon. Here is the one thing you need to say back. The next time someone tells you these parents were trying to ban books, tell them this. They never asked the school to remove a single book. They never asked the school to stop reading these books to other children. They asked for a phone call before the lesson so they could take their child to the library for 30 minutes. That is the entire case. That is what $6.1 million of public money was spent fighting. And when the school lost at the Supreme Court 6-3, and the opt-out system was finally put in place, 56 families out of 156,000 students used it. Not chaos. 56 families. You don't need to win that argument. You just need to say that. Because it is true, it is on the record, and it does not require your opponent to agree with your values. It only requires them to agree with the facts. Here is what happened in this case. A school district decided that the religious beliefs of its Muslim, Catholic, Ukrainian Orthodox, and Jewish families were not beliefs worth accommodating. A board member said so on the record, that honoring religious opt-outs would teach children their parents' values were another reason to hate another person. That is not an administrator making a scheduling call. That is a government official deciding that your faith is a form of bigotry, and using the compulsory power of the state to act on that judgment. The parents fought back. For 2 years in federal court, they lost. Then they won. And the winning looks like this. $6.1 million returned to accountability, a permanent injunction protecting every religious parent in that district, and a Supreme Court opinion that is live law from California to Maryland. The system worked. Not easily, not quickly, not without cost, but it worked. Because the parents did not accept the framing that their concern was unreasonable. Because they knew the difference between being told to tolerate something and being told to endorse it. And because they were right. I am John Gray. This is Logic Bridge. You are not unreasonable. You are not hateful. You are a parent. And the Supreme Court of the United States just agreed with you.